Restraint of trade back in the headlines this year. There were two cases involving media groups Fairfax and Channels 10 and 7 and the departure of members of their executive teams. One point to note about both these cases was how the employer reacted and the steps they took once they were informed of the executive that had decided to resign. Here to discuss these cases and restraint of trade issues is our regular workplace law commentator, Joydeep Hor. Joydeep is Managing Principal of specialist employment law firm People and Culture Strategies. Joydeep, good to have you on the show. Thank you.
Thanks, Brooke.
You have to remind us, though, of these cases, you know, quite high profile, I guess, but just kind of you can summarise, firstly, the Fairfax versus Harrison case.
Yeah, so in this case you had a senior executive of Fairfax who was going to go to Yahoo. In his contract there was a provision that said for 12 months after his employment was terminated he couldn't solicit any business, and this was someone who was dealing essentially with the main advertisers of Fairfax. There was also a provision that said for 6 months after the termination of his employment, regardless of whether it was the employer terminating or him resigning, he couldn't work for a competitor. What the interesting thing was about this case was that by the time all of the exchange of letters to and fro between the old employer and the new employer, which is quite commonly how these things play out. He resigned in December, was immediately put on garden leave, and then it got to sort of April or May by the time they actually got to the court, and at that stage Fairfax were arguing that, well, you know, it's all very urgent, we need to have this injunction. But what they were effectively talking about was a period of only a couple of weeks.
Right.
And so the court said, well, look, realistically, to enforce these restraints, you kind of had 4 or 5 months. You really should have acted a lot more quickly. Now, it's an interesting point out of that one because a lot of employers would say, well, we're just trying to sort it out amicably without having to come to court. But if you don't move quickly, it could actually work against you, and that's one of the key learnings from this particular.
Right, so there's a timing issue in that one. What about the Network 10 versus 7 network and John Stevens?
Yeah, very, very high-profile case, and this one was an interesting one because we had an individual who accepted an offer to go to 10. That was countered when he communicated that to 7, an offer that was too good to refuse, so he effectively decided to not proceed with the offer with 10. 10 said, well, actually, no, it's the horse has bolted on that. You have accepted this offer even though you haven't started. We're going to say that you can't accept work for a competitor even though he was already there.
Yeah, right. Messy, hey?
And so the question becomes, well, yes, you've got a contract that has been signed. On its face, there's a restraint that says you can't work for a competitor, but the person hasn't actually started with the new organisation. Has the restraint actually become enlivened is the language that's used? And the court takes a pretty sensible view and says, yeah, look, the contract's one thing, but the reality is the person hasn't set foot in your organisation. So for you to say that, OK, this person's so valuable, it's the face of our organisation, has access to all this confidential information, is probably gilding the lily a little bit too much.
OK, so what do we learn about, I guess, when an employer should decide to actually act and enforce a restraint in a contract?
The most critical issue for employers is you will never get the opportunity at the time that you want to push the button on legal proceedings to rewrite or reshape the key document and key clause that you are going to be working with. You've got to get that right up front. So if you anticipate that that's something that you're going to need to rely on, whether that's in the exchange of correspondence or pushing the button in legal proceedings, you need to make sure that the wording of that is watertight. It's got to be reasonable. Each jurisdiction in Australia, whether it's New South Wales, Victoria, whatever, will have its own system. So this is a state-by-state issue, not a Commonwealth issue. Each of the states have their own nuances around how far they will be prepared to enforce these kinds of restraints. Critical message for employers is, what is the business interest that you are seeking to protect? The mere fact that you're narky and angry that someone is going to a competitor, which everyone gets is human nature, is not going to be sufficient for a court to say, well, just because you're annoyed about this, I'm going to enforce a restraint that's going to put someone out of play from working for a competitor of yours. Because a person should be entitled to work wherever they want to work, but fair enough, if the employer is protecting something which they have invested a lot of time and money in, to a particular employee, it might be a different proposition.
And one final question out of all of that, just to sum up, and briefly if we can, I know it's difficult, but Fairfax and 7, in both those cases, they didn't actually pursue the matter to a final hearing. Now, why was that? What do we read into that? And again, a takeaway maybe.
Yeah, so the critical issue in these kinds of cases is that it's the interlocutory or interim or more immediate steps that are taken. And what happens is the employer that's aggrieved tries to get an interlocutory injunction, so that's like an injunction for the holding pattern pattern, pending the final case, which might not be for several months. But that is the win, and often the only win that the employer really wants, because that's enough to mitigate the damage. You've effectively got what you want for a period of however many months. It's going to take at least that long before it goes to a final hearing. So you either win or lose that upfront battle, and that'll determine whether you push the button on it later anyway.
But basically get it watertight before we even get to that point.
Yeah.
Joydeep Hor, thank you very much.
Thanks,
from People
Brooke.
and Culture Strategies, as always. Great to have you on the show.